this is such a, I didn't realize we were going to get on this topic, but this is such an important topic, and it's been well covered by the panel. But there's a few takeaways, I think, that everyone in this room who's got some commercial property, particularly, or even a multifamily residential, should take away. One is this: the designation is CASP, as Bill said, CASP. And I think it might be even on the Department of Bureau of Real Estate website, there's a whole list of consultants. This is money well spent. Don't try to figure out the regulations by yourself. It's impossible. There are so many regulations, and these consultants have some software. They'll go visit your building, and they'll generate a report that's maybe 20 to 40 pages with pictures. Here's the rule. Here's what you have. Either it's in compliance, it's not in compliance. Here's why. The sink should be 1.5 inches higher. You're 1.5 inches lower. Your wheelchair access should be this wide instead of this wide. Use the consultant. It's a little bit of money, but well worth it. And it's a defensive mechanism, too. And they turn around these reports pretty fast. We've had it done on 2 separate buildings, and it's very valuable. And you cannot replicate that level of accuracy or information without using a consultant. So I definitely, if you have this concern, it's a CASP consultant, C-A-S-P. Get a referral, get someone out there, look at your property. Then you can give it to your landlord or your client and say, hey, look, he says you got to do 85 different things to bring your building into a compliance. Well, then you have a business issue. Well, how many of these are like, musts? How many of those are probablies? And how many are like, look, I can't do that this year or never, or it's a minor issue. It's not significant. And the other thing to keep in mind as a takeaway is that, these lawsuits, they work kind of like in a different area of law. They're sort of high volume lawsuits, generally low dollar value. Still, you don't want to pay it, but they're usually in the $2,000 to $10,000 to $20,000 range. There are some outliers, but this is where an attorney will, with usually a particular client, will target like the 800 block of Sepulveda and just go up and down the block, and then the letters will follow. And that's how this is done. And it's a means of enforcement. That's the way the legislature chose to enforce it. And the other takeaway I would say from Mo's story is, if you're an owner of a real estate asset or a business or a multifamily, open your mail and read it. And if it has a letter from an attorney, don't throw them away. We attorneys are not known for being, quitters. We don't give up. We just look, oh, great, that person's ignoring us. Let's just go forward. And the law is what they call a compulsory process. You can't opt out once you get sued. You either appear or you're going to get a default judgment against you.